very much, Charlie. Among several things I do, I chair the New Nicotine Alliance, which is a small consumer advocacy organisation which promotes tobacco harm reduction. I'd like to thank the trustees for their wisdom in seeing that e-cigarettes don't work for everyone and that there needs to be a wide range of alternative lower-risk nicotine products. I'd also like to thank our barrister, Paul Diamond, who's working pro bono for us on this case, and it's the first time I've been at a conference where I can say that I'll be careful what I say because my lawyer is present. Prime tobacco harm reduction candidate product, low risk profile. You heard Peter Lee this morning giving the evidence for the relative safety of snus. Low tech. If the Green Party had a nicotine product of choice, it would be snus. No batteries, no wires, no fiddly things. Just open the tin, pop it in your mouth. No inhalation. So very good risk profile. And you will have seen also in your packs, and there's the poster by Lars Ramstrong, which is part of the argument that snus protects against smoking and ill health. It protects by helping people to switch from smoking, by helping people reduce smoking, and helps prevent smoking. Younger people in Sweden choosing to use snus rather than to smoke. And it's Swedish men who do harm reduction, despite the fact that the Swedish government doesn't like to talk a lot about harm reduction. But the latest Eurobarometer data on smoking prevalence are quite stunning, showing that Swedish adult smoking prevalence is down to 5%. And Sweden has the lowest tobacco-related mortality in the EU. And Lars's calculations show that retrospectively, 355,000 premature deaths occur across the EU because the EU has not adopted snus in the way it has been adopted in Sweden. And looking forward, it would be about 320,000 deaths averted per year if the rest of Europe took up snus, or was able to take up snus in the same way as taken up in Sweden. But snus is banned. The EU Tobacco Products Directive and all legislation in the EU has a very canny definition which, in terms of oral tobaccos, it's all right if you sniff or chew, but don't suck. So you can't sell tobaccos to suck, but you can sell other tobaccos to chew or to sniff. Deliberately designed to ban snus. So there's a long history of the ban, and these slides you can see on the NNA website and the conference website later. The legal challenge was initiated by Swedish Match, the main producer of snus in Sweden, and it's brought technically against the UK Department of Health because you have to bring a challenge in a nation state, and their case against the ban on the marketing of snus is on commercial grounds within EU legislation, that the legislation discriminates against snus compared with cigarettes. It's disproportionate. It's against the principle in the EU of subsidiarity, which means national states should be able to have regulatory discretion. No reasons given for the ban, and is an unjustified restriction on the free movement of goods. So that case was initiated last year by Swedish Match, and NNA, when it heard about the case, asked to be joined to the action. In the UK law, you can join another action as a third-party public interest organisation. Technically, you're an intervener. So when the case is heard in the court, you can apply to join the case, and that's what our barrister Paul Diamond stood up and made the argument to a very nice judge who's pictured there. And the judge agreed both that the case could go forward, but also that NNA could be joined to the action. And you can see that Jessica Hardin, NNA's administrator, and I were very happy when we left Court 18 with the news that both that NNA could be joined to the action, but also that the case would be referred to the European Court of Justice. And that's because UK law is based in European law, so the UK court can't decide the legal issues. It has to be passed to the European Court of Justice. And we are still in the European Union and under jurisdiction of the European Court of Justice in the time it will take for this case to be heard. We're not yet in Brexit land. So the NNA case is actually a different one, and this is what we bring to the argument, and it's based in a human rights argument about the right to have access to products which help you protect you from smoking. And that's a nice twist, because all EU law has to take account of a high level of health protection, which is usually taken to mean protecting people from things. And we're arguing that actually that also means helping people protect themselves by having access to safer products. So there are 3 articles in the EU Charter of Fundamental Rights which are relevant, both human dignity, respect for private life, and also on health care. And we think we're onto an interesting thing here, if only that when this case gets to the ministers of health around Europe, as it does, they'll look at this and think, okay, what's the right to health argument? You know, we know all about bashing on about the commercial arguments, and what are they trying to argue here, and how can we actually argue against a human rights argument? So I think we're kind of into a nice little niche here, which will be challenging for those who might oppose the action. Legal process takes time, started last June. We are now at the orange bit, and that's submissions going. The European Court of Justice has asked for written observations, and all member states and the European institutions can write written observations. And then in December or January, we get our 20 minutes in court where Paul Diamond will argue our case before the European Court of Justice. So, implications. First time ever, I think, that a bad tobacco control law has been challenged on the basis of human rights. This has implications for other challenges and has implications for other countries. Our legal advisor says, well, even if we lose, we've kind of won because we've introduced a whole new discourse on challenging law. So that's, you know, and so there's a step. Third thing, small organisations can do big things. NNA, small, donor-funded, you know, works on donations. You can do big things. And the final point is that if there's a big if the judgment went the way we'd like it to go, it applies across Europe. So it's not just the UK; it applies across Europe. Although then we'll be out of Europe and trying to look after our own affairs. So there are, you know, as Deborah said, you know, the review process for all of this is going, you know, whether in or out and all the rest of it is going to take some time. But interesting that we've kind of got this far, and by the time we meet next year, I think if I read the schedule right, we won't have an answer though this time next year because legal processes take time, but sooner or later I will tell you the result. Thank you.